To insure a multi-million-dollar industrial asset, the legal language on the policy must mirror the physical reality on the factory floor. When that reflection distorts, you get the dispute between Satya Maharshi Power Corporation and IFCO Tokyo General Insurance, a fight over a repudiated multi-crore machinery breakdown claim. This multi-million-dollar dispute involves a specific 11-stage turbine rotor, similar to this assembly, which suffered severe damage during operations. On March 26, 2012, the insurer officially denied the claim. The decision followed a years-long failure to provide material disclosures about the hardware's origins. This case demonstrates how corporate subsidiaries, attempting to solve an engineering problem internally, can inadvertently erase their own insurance coverage. The physical timeline begins in Guntur, Andhra Pradesh, at a power plant operated by the complainant. Their parent company also owned a distinct subsidiary plant located in Khammam, run by Rithwik Power Projects. Because they were set up by the exact same parent organization, both power plants operated identical 11-stage turbine rotors. Parts from one location could physically fit into the other. In July 2008, the Guntur plant's rotor was severely damaged. Over at Khammam, the sister plant had recently upgraded to a 20-stage rotor, leaving their older 11-stage unit sitting idle. The parent company recognized a clear engineering solution: transport the idle rotor from Khammam and plug it into the damaged turbine in Guntur. However, hardware compatibility does not equal insurance compatibility. This flowchart, submitted as evidence, shows how the two rotors moved. Initially, the physical movement aligned with the paperwork. Both the damaged Guntur rotor and the idle Khammam rotor went to a facility in Hyderabad for technical assessment. To protect the hardware during that journey, the Guntur plant took out a marine transit policy. That contract covered their specific rotor from Guntur to Hyderabad and straight back to Guntur. The Khammam plant secured a separate marine transit policy for their spare rotor. That document restricted coverage to the exact route from Khammam to Hyderabad and back to Khammam. At this stage, the paper trail of insurance policies perfectly accounts for the physical location of the equipment. The entire claim collapses on the return trip. Instead of returning to Khammam, the idle rotor was diverted from Hyderabad directly to the Guntur plant. There was no transit policy covering the journey from Hyderabad to Guntur. Compounding the error, the erection all risks policies for physical installation were taken out by the Khammam entity for the Khammam location. The Guntur installation remained unprotected. Commercial insurance policies operate on strict entity boundaries. A policy purchased by subsidiary A for location A does not cover subsidiary B at location B, despite sharing a parent. By quietly swapping the physical rotor to save downtime, the parent company effectively swapped the hardware out of its legal coverage. The complainant argued they did disclose the swap. They pointed to emails sent to their broker, claiming that informing the broker was legally equivalent to informing the insurance company. The legal framework states otherwise. Under the Insurance Regulatory and Development Authority Act, there is a strict firewall between an insurance broker and an insurance agent. A broker is legally defined as a facilitator who works for the client to arrange coverage. Telling your broker is effectively telling your own consultant. The complainant relied on internal board memos and uncopied emails shared only with this broker. None of that data officially reached the insurer's underwriters. Assuming a broker acts as a legal proxy for an insurer is an error that nullifies the entire premise of commercial risk transfer. Attempting another defense, the complainant pointed out that the insurer's own surveyor physically inspected the Guntur turbine before the breakdown policy was finalized. They argued this inspection constituted an acceptance of the risk. But the surveyor was evaluating a fully assembled turbine presented to him as a repaired unit. No one handing him a document stated the internal rotor was a second-hand replacement from an entirely different corporate entity. Insurance contracts are governed by the principle of uberrime fide, utmost good faith. The insured has an absolute duty to provide explicit written disclosure of any altered risk. The defense argued this omission was material. The substituted rotor from Khammam was allegedly defective prior to the transfer, a fact the underwriters could have used to decline the risk had it been disclosed. A physical inspection is only as valid as the disclosures that precede it. A clean report does not waive the fundamental duty of transparency. This document, submitted by the defense, lists the missing evidence in the case. The complainant claimed to have valid transit and direction policies for the Guntur leg. But as items 1 and 2 show, those documents were never produced. This second page lists the internal communications relied on by the complainant. Items 8, 9, and 10 confirm these private letters were never shared with the insurer. The defense also highlighted missing witnesses. No technical officials were called to verify the Rotor's fitness. Without those policies and witness testimonies, the Commission ruled that the chain of custody for material information had been broken. The Commission upheld the repudiation. The insurer was legally justified in denying the claim because the installation of a second-hand rotor from a different entity was a material fact that was not disclosed. The ruling reiterates the standard. Insurance brokers are facilitators for the insured, and communications with them do not constitute notice to the insurer. For corporate risk managers, the mandate is clear. Moving industrial assets across geographic or corporate boundaries requires explicit, documented policy endorsements. In industrial risk management, intent is irrelevant. If the physical reality of the machine and the contractual reality of the policy do not perfectly align, the corporation
Zuber & Company, fire forensic experts and forensic engineers. Seeking answers from ashes. Seeking answers.